Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Mallory v. Norfolk Southern Railway Co. In this case, the court considered this issue. Does a state registration statute for out-of-state corporations that purports to confer general personal jurisdiction over the registrant violate the Due Process Clause of the 14th Amendment? The case was decided on June 27, 2023. The Supreme Court held that a Pennsylvania law requiring out-of-state companies that register to do business in Pennsylvania to agree to appear in Pennsylvania courts on any cause of action against them comports with the Due Process Clause. Justice Neil Gorsuch authored the main opinion of the court. The outcome in this case is controlled by the court's decision in Pennsylvania Fire Insurance Company v. Gold Issue Mining and Milling Company, which held that suits based on the defendant's consent to jurisdiction do not deny the defendant due process of law. The Pennsylvania Supreme Court concluded otherwise based on its erroneous belief that the court had implicitly overruled Pennsylvania Fire in International Shoe Company v. Washington. However, rather than displace Pennsylvania Fire, International Shoe merely paved an additional road to jurisdiction over out-of-state corporations. Thus, the facts of this case fall squarely within Pennsylvania Fire, and there is no due process violation. Justice Ketanji Brown Jackson authored a concurring opinion noting another precedent, Insurance Corporation of Ireland v. Compagnie des Bauxites de Guinée, which she finds particularly instructive. Justice Samuel Alito authored an opinion concurring in part and concurring in the judgment. Justice Alito agreed with the plurality that exercising jurisdiction pursuant to the state registration statute does not violate the Due Process Clause, but he opined that the statute might be unconstitutional on other grounds not before the court. Justice Amy Coney Barrett authored a dissenting opinion, in which Chief Justice John Roberts and Justices Elena Kagan and Brett Kavanaugh joined, arguing that compelled state registration does not constitute consent. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Gorsuch announced the judgment of the court, and delivered the opinion of the court with respect to Parts 1 and 3b, and an opinion with respect to Parts 2, 3, A and 4, in which Justice Thomas, Justice Sotomayor, and Justice Jackson join. Imagine a lawsuit based on recent events. A few months ago, a Norfolk Southern train derailed in Ohio near the Pennsylvania border. Its cargo? Hazardous chemicals? Some poured into a nearby creek, some burst into flames. In the aftermath, many residents reported unusual symptoms. Suppose an Ohio resident sued the train conductor seeking compensation for an illness attributed to the accident. Suppose, too, that the plaintiff served his complaint on the conductor across the border in Pennsylvania. Everyone before us agrees a Pennsylvania court could hear that lawsuit consistent with the Due Process Clause of the 14th Amendment. The court could do so even if the conductor was a Virginia resident who just happened to be passing through Pennsylvania when the process server caught up with him. Now, change the hypothetical slightly. Imagine the same Ohio resident brought the same suit in the same Pennsylvania state court, but this time against Norfolk Southern. Assume, too, the company has filed paperwork consenting to appear in Pennsylvania courts as a condition of registering to do business in the Commonwealth. Could a Pennsylvania court hear that case too? You might think so. But today, Norfolk Southern argues that the Due Process Clause entitles it to a more favorable rule, one shielding it from suits even its employees must answer. We reject the company's argument. Nothing in the Due Process Clause requires such an incongruous result. Robert Mallory worked for Norfolk Southern as a freight car mechanic for nearly 20 years, first in Ohio, then in Virginia. During his time with the company, Mr. Mallory contends, he was responsible for spraying boxcar pipes with asbestos and handling chemicals in the railroad's paint shop. He also demolished car interiors that, he alleges, contained carcinogens. After Mr. Mallory left the company, he moved to Pennsylvania for a period before returning to Virginia. Along the way, he was diagnosed with cancer. Attributing his illness to his work for Norfolk Southern, Mr. Mallory hired Pennsylvania lawyers and sued his former employer in Pennsylvania State Court under the Federal Employers' Liability Act. That law creates a workers' compensation scheme permitting railroad employees to recover damages for their employer's negligence. Norfolk Southern resisted Mr. Mallory's suit on constitutional grounds. By the time he filed his complaint, the company observed, Mr. Mallory resided in Virginia. His complaint alleged that he was exposed to carcinogens in Ohio and Virginia. Meanwhile, the company itself was incorporated in Virginia and had its headquarters there too. On these facts, Norfolk Southern submitted, any effort by a Pennsylvania court to exercise personal jurisdiction over it would offend the Due Process Clause of the 14th Amendment. Mr. Mallory saw things differently. He noted that Norfolk Southern manages over 2,000 miles of track, operates 11 rail yards, and runs 3 locomotive repair shops in Pennsylvania. He also pointed out that Norfolk Southern has registered to do business in Pennsylvania in light of its regular, systematic, and extensive operations there. That is significant? Mr. Mallory argued, because Pennsylvania requires out-of-state companies that register to do business in the Commonwealth to agree to appear in its courts on any cause of action against them. By complying with this statutory scheme, Mr. Mallory contended, Norfolk Southern had consented to suit in Pennsylvania on claims just like his. Ultimately, the Pennsylvania Supreme Court sided with Norfolk Southern. Yes, Mr. Mallory correctly read Pennsylvania law. It requires an out-of-state firm to answer any suits against it in exchange for status as a registered foreign corporation and the benefits that entails. But no, the court held, Mr. Mallory could not invoke that law because it violates the Due Process Clause. In reaching this conclusion, the Pennsylvania Supreme Court acknowledged its disagreement with the Georgia Supreme Court, which had recently rejected a similar due process argument from a corporate defendant. In light of this split of authority, we agreed to hear this case and decide whether the Due Process Clause of the 14th Amendment prohibits a state from requiring an out-of-state corporation to consent to personal jurisdiction to do business there. The question before us is not a new one. In truth, it is a very old question, and one this court resolved in Pennsylvania Fire-Inns Company of Philadelphia v. Gold Issue Mining and Milling Company. There, the court unanimously held that laws like Pennsylvania's comport with the Due Process Clause. Some background helps explain why the court reached the result it did. Both at the time of the founding and the 14th Amendment's adoption, the Anglo-American legal tradition recognized that a tribunal's competence was generally constrained only by the territorial limits of the sovereign that created it. That principle applied to all kinds of actions, but cashed out differently based on the object of the court's attention. So, for example, an action in rem that claimed an interest in immovable property was usually treated as a local action that could be brought only in the jurisdiction where the property was located. Meanwhile, an in personam suit against an individual for injuries that might have happened anywhere was generally considered a transitory action that followed the individual, all of which meant that a suit could be maintained by anyone on any claim in any place the defendant could be found. American courts routinely followed these rules. Chief Justice Marshall, for one, was careful to distinguish between local and transitory actions in a case brought by a Virginia plaintiff against a Kentucky defendant based on a fraud perpetrated in Ohio. Because the action was a transitory one that followed the individual, he held, the suit could be maintained wherever the defendant may be found. This rule governing transitory actions still applies to natural persons today. Some call it tag jurisdiction, and our leading case applying the rule is not so old. The case began with Dennis Burnham's business trip to California. During his short visit, Mr. Burnham's estranged wife served him with a summons to appear in California State Court for divorce proceedings. This court unanimously approved the state court's exercise of personal jurisdiction over Mr. Burnham as consistent with the Due Process Clause, and did so even though the Burnhams had spent nearly all their married life in New Jersey, and Mr. Burnham still resided there. As the use of the corporate form proliferated in the 19th century, the question arose, how to adapt the traditional rule about transitory actions for individuals to artificial persons created by law. Unsurprisingly, corporations did not relish the prospect of being hailed into court for any claim anywhere they conducted business. No one, after all, has ever liked greeting the process server. Corporations chartered in one state sought the right to send their sales agents and products freely into other states. At the same time, when confronted with lawsuits in those other states, some firms sought to hide behind their foreign character and deny their presence to defeat the court's jurisdiction. Lawmakers across the country soon responded to these stratagems. Relevant here, both before and after the 14th Amendment's ratification, they adopted statutes requiring out-of-state corporations to consent to in-state suits in exchange for the rights to exploit the local market and to receive the full range of benefits enjoyed by in-state corporations. These statutes varied. In some states, out-of-state corporate defendants were required to agree to answer suits brought by in-state plaintiffs. In other states, corporations were required to consent to suit if the plaintiff's cause of action arose within the state, even if the plaintiff happened to reside elsewhere. Still other states and the federal government omitted both of these limitations. They required all out-of-state corporations that registered to do business in the forum to agree to defend themselves there against any manner of suit. Yet another group of states applied this all-purpose jurisdiction rule to a subset of corporate defendants, like railroads and insurance companies. Mr. Mallory has collected an array of these statutes, enacted between 1835 and 1915, in his statutory appendix. Unsurprisingly, some corporations challenge statutes like these on various grounds, due process included. And, ultimately, one of these disputes reached this court in Pennsylvania Fire. That case arose this way. Pennsylvania Fire was an insurance company incorporated under the laws of Pennsylvania. In 1909, the company executed a contract in Colorado to insure a smelter located near the town of Cripple Creek, owned by the Gold Issue Mining and Milling Company. Less than a year later, lightning struck and a fire destroyed the insured facility. When Gold Issue Mining sought to collect on its policy, Pennsylvania Fire refused to pay. So, Gold Issue Mining sued, but it did not sue where the contract was formed. Colorado, or in its home state, Arizona, or even in the insurer's home state, Pennsylvania. Instead, Gold Issue Mining brought its claim in a Missouri state court. Pennsylvania Fire objected to this choice of forum. It said the Due Process Clause spared it from having to answer in Missouri's courts a suit with no connection to the state. The Missouri Supreme Court disagreed. It first observed that Missouri law required any out-of-state insurance company desiring to transact any business in the state to file paperwork agreeing to 1. Appoint a state official to serve as the company's agent for service of process, and 2. Accept service on that official as valid in any suit. For more than a decade, Pennsylvania Fire had complied with the law, as it had desired to transact business in Missouri pursuant to the laws thereof, and Gold Issue Mining had served process on the appropriate state official, just as the law required. As to the law's constitutionality, the Missouri Supreme Court carefully reviewed this court's precedents and found they clearly supported sustaining the proceeding. The Missouri Supreme Court explained that its decision was also supported by the origin, growth, and history of transitory actions in England, and their importation, adoption, and expansion in America. It stressed too that the law had long permitted suits against individuals in any jurisdiction where they could be found, no matter where the underlying cause of action happened to arise. What sense would it make to treat a fictitious corporate person differently? For all these reasons, the court concluded, Pennsylvania Fire had due process of law, regardless of the place, state, or nation where the cause of action arose. Dissatisfied with this answer, Pennsylvania Fire turned here. Writing for a unanimous court, Justice Holmes had little trouble dispatching the company's due process argument. Under this court's precedents, there was no doubt Pennsylvania Fire could be sued in Missouri by an out-of-state plaintiff on an out-of-state contract, because it had agreed to accept service of process in Missouri on any suit as a condition of doing business there. Indeed, the court thought the matter so settled by existing law that the case hardly presented an open question. The court acknowledged that the outcome might have been different if the corporation had never appointed an agent for service of process in Missouri, given this court's earlier decision in Old Wayne. But the court thought that Old Wayne had left untouched the principle that due process allows a corporation to be sued on any claim in a state where it has appointed an agent to receive whatever suits may come. The court found it unnecessary to say more because the company's objections had been resolved at length in the judgment of the court below. That assessment was understandable. Not only had the Missouri Supreme Court issued a thoughtful opinion, not only did a similar rule apply to transitory actions against individuals, other leading judges, including Learned Hand and Benjamin Cardozo, had reached similar conclusions in similar cases in the years leading up to Pennsylvania Fire. In the years following Pennsylvania Fire, too, this court reaffirmed its holding as often as the issue arose. Pennsylvania Fire controls this case. Much like the Missouri law at issue there, the Pennsylvania law at issue here provides that an out-of-state corporation may not do business in this Commonwealth until it registers with the Department of State. As part of the registration process, a corporation must identify an office it will continuously maintain in the Commonwealth. Upon completing these requirements, the corporation shall enjoy the same rights and privileges as a domestic entity, and shall be subject to the same liabilities, restrictions, duties and penalties imposed on domestic entities. Among other things, Pennsylvania law is explicit that qualification as a foreign corporation shall permit state courts to exercise general personal jurisdiction over a registered foreign corporation, just as they can over domestic corporations. Norfolk Southern has complied with this law for many years. In 1998, the company registered to do business in Pennsylvania. Acting through its corporate secretary as a duly authorized officer, the company completed an application for Certificate of Authority from the Commonwealth in compliance with state law. As part of that process, the company named a commercial registered office provider in Philadelphia County, agreeing that this was where it shall be deemed located. The Secretary of the Commonwealth approved the application, conferring on Norfolk Southern both the benefits and burdens shared by domestic corporations, including amenability to suit in state court on any claim. Since 1998, Norfolk Southern has regularly updated its information on file with the Secretary. In 2009, for example, the company advised that it had changed its registered office provider and would now be deemed located in Dauphin County. All told then, Norfolk Southern has agreed to be found in Pennsylvania and answer any suit there for more than 20 years. Pennsylvania Fire held that suits premised on these grounds do not deny a defendant due process of law. Even Norfolk Southern does not seriously dispute that much. It concedes that it registered to do business in Pennsylvania, that it established an office there to receive service of process, and that in doing so it understood it would be amenable to suit on any claim. Of course, Mr. Mallory no longer lives in Pennsylvania, and his cause of action did not accrue there. But none of that makes any more difference than the fact that Gold Issue Mining was not from Missouri, but from Arizona, and its claim did not arise there but in Colorado. To decide this case, we need not speculate whether any other statutory scheme and set of facts would suffice to establish consent to suit. It is enough to acknowledge that the state law and facts before us fall squarely within Pennsylvania Fire's rule. In the proceedings below, the Pennsylvania Supreme Court seemed to recognize that Pennsylvania Fire dictated an answer in Mr. Mallory's favor. Still, it ruled for Norfolk Southern anyway. It did so because, in its view, intervening decisions from this court had implicitly overruled Pennsylvania Fire. But in following that course, the Pennsylvania Supreme Court clearly erred. As this court has explained, if a precedent of this court has direct application in a case, as Pennsylvania Fire does here, a lower court should follow the case which directly controls, leaving to this court the prerogative of overruling its own decisions. This is true even if the lower court thinks the precedent is in tension with some other line of decisions. Now before us, Norfolk Southern candidly asks us to do what the Pennsylvania Supreme Court could not: overrule Pennsylvania Fire. To smooth the way, Norfolk Southern suggests that this court's decision in International Shoe Company v. Washington has already done much of the hard work for us. That decision, the company insists, seriously undermined Pennsylvania Fire's foundations. We disagree? The two precedents sit comfortably side by side. Start with how Norfolk Southern sees things. On the company's telling, echoed by the dissent, International Shoe held that the Due Process Clause tolerates two, and only two, types of personal jurisdiction over a corporate defendant. First, specific jurisdiction permits suits that arise out of or relate to a corporate defendant's activities in the forum state. Second, general jurisdiction allows all kinds of suits against a corporation, but only in states where the corporation is incorporated or has its principal place of business. After International Shoe, Norfolk Southern insists, no other bases for personal jurisdiction over a corporate defendant are permissible. But if this account might seem a plausible summary of some of our International Shoe jurisprudence, it oversimplifies matters. Here is what really happened in International Shoe. The state of Washington sued a corporate defendant in state court for claims based on its in-state activities even though the defendant had not registered to do business in Washington and had not agreed to be present and accept service of process there. Despite this, the court held that the suit against the company comported with due process. In doing so, the court reasoned that the 14th Amendment permits suits against a corporate defendant that has not agreed to be present within the territorial jurisdiction of a court, so long as the quality and nature of the company's activity in the state make it reasonable and just to maintain suit there. Put simply, even without agreeing to be present, the out-of-state corporation was still amenable to suit in Washington, consistent with fair play and substantial justice terms. The court borrowed from Justice Holmes, the author of Pennsylvania Fire. In reality, then, all International Shoe did was stake out an additional road to jurisdiction over out-of-state corporations. Pennsylvania Fire held that an out-of-state corporation that has consented to in-state suits in order to do business in the forum is susceptible to suit there. International Shoe held that an out-of-state corporation that has not consented to in-state suits may also be susceptible to claims in the forum state based on the quality and nature of its activity in the forum. Consistent with all this, our precedents applying International Shoe have long spoken of the decision as asking whether a state court may exercise jurisdiction over a corporate defendant that has not consented to suit in the forum. Our precedents have recognized, too, that express or implied consent can continue to ground personal jurisdiction, and consent may be manifested in various ways by word or deed. That Norfolk Southern overreads International Shoe finds confirmation in that decision's emphasis on fair play and substantial justice. Sometimes, International Shoe said, the nature of a company's in-state activities will support jurisdiction over a non-consenting corporation when those activities give rise to the liabilities sued on. Other times, it added, suits on causes of action arising from dealings entirely distinct from the company's activities in the forum state may be appropriate. These passages may have pointed the way to what later cases would label specific jurisdiction over claims related to in-forum activities and general jurisdiction in places where a corporation is incorporated or headquartered. But the fact remains that International Shoe itself eschewed any mechanical or quantitative test, and instead endorsed a flexible approach focused on the fair and orderly administration of the laws, which it was the purpose of the Due Process Clause to ensure. Unquestionably, too, International Shoe saw this flexible standard as expanding, not contracting, state court jurisdiction. As we later put the point, the immediate effect of International Shoe was to increase the ability of the state courts to obtain personal jurisdiction over non-resident defendants. Given all this, it is no wonder that we have already turned aside arguments very much like Norfolk Southern's. In Burnham, the defendant contended that International Shoe implicitly overruled the traditional tag rule, holding that individuals physically served in a state are subject to suit there for claims of any kind. This court rejected that submission. Instead, as Justice Scalia explained, International Shoe simply provided a novel way to secure personal jurisdiction that did nothing to displace other traditional ones. What held true there must hold true here. Indeed, 7 years after deciding International Shoe, the court cited Pennsylvania Fire approvingly. Norfolk Southern offers several replies, but none persuades. The company begins by pointing to this court's decision in Schaffer. There, as the company stresses, the court indicated that prior decisions inconsistent with international shoe are overruled. True as that statement may be, however, it only poses the question whether Pennsylvania fire is inconsistent with international shoe. And, as we have seen, it is not. Instead, the latter decision expanded upon the traditional grounds of personal jurisdiction recognized by the former. This court has previously cautioned litigants and lower courts against misreading Schaffer as suggesting that international shoe discarded every traditional method for securing personal jurisdiction that came before. We find ourselves repeating the admonition today. Next, Norfolk Southern appeals to the spirit of our age. After international shoe, it says, the primary concern of the personal jurisdiction analysis is treating defendants fairly. And on the company's telling, it would be unfair to allow Mr. Mallory's suit to proceed in Pennsylvania, because doing so would risk unleashing local prejudice against a company that is not local in the eyes of the community. But if fairness is what Norfolk Southern seeks, pause for a moment to measure this suit against that standard. When Mr. Mallory brought his claim in 2017, Norfolk Southern had registered to do business in Pennsylvania for many years. It had established an office for receiving service of process. It had done so pursuant to a statute that gave the company the right to do business in-state in return for agreeing to answer any suit against it. And the company had taken full advantage of its opportunity to do business in the Commonwealth, boasting of its presence this way, citing a website for the railway. All told, when Mr. Mallory sued, Norfolk Southern employed nearly 5,000 people in Pennsylvania. It maintained more than 2,400 miles of track across the Commonwealth. Its 70-acre locomotive shop there was the largest in North America. Contrary to what it says in its brief here, the company even proclaimed itself a proud part of the Pennsylvania community. By 2022, Norfolk Southern managed more miles of track in Pennsylvania than in any other state, and it employed more people in Pennsylvania than it did in Virginia, where its headquarters was located. Nor are we conjuring these statistics out of thin air. The company itself highlighted its intrastate activities in the proceedings below, discussing the firm's extensive operations in Pennsylvania, including 2,278 miles of track, 11 rail yards, and 3 locomotive repair shops. Given all this, on what plausible account could international shoe's concerns with fair play and substantial justice require a Pennsylvania court to turn aside Mr. Mallory's suit? Perhaps sensing its arguments from fairness meet a dead end, Norfolk Southern ultimately heads in another direction altogether. It suggests the Due Process Clause separately prohibits one state from infringing on the sovereignty of another state through exorbitant claims of personal jurisdiction. And, in candor, the company is half right. Some of our personal jurisdiction cases have discussed the federalism implications of one state's assertion of jurisdiction over the corporate residence of another. But that neglects an important part of the story. To date, our personal jurisdiction cases have never found a due process clause problem sounding in federalism when an out-of-state defendant submits to suit in the forum state. After all, personal jurisdiction is a personal defense that may be waived or forfeited. That leaves Norfolk Southern one final stand. It argues that it has not really submitted to proceedings in Pennsylvania. The company does not dispute that it has filed paperwork with Pennsylvania seeking the right to do business there. It does not dispute that it has established an office in the Commonwealth to receive service of process on any claim. It does not dispute that it appreciated the jurisdictional consequences attending these actions, and proceeded anyway, presumably because it thought the benefits outweighed the costs. But, in the name of the Due Process Clause, Norfolk Southern insists we should dismiss all that as a raft of meaningless formalities. Taken seriously, this argument would have us undo, not just Pennsylvania fire, but a legion of precedents that attach jurisdictional consequences to what some might dismiss as mere formalities. Consider some examples we have already encountered. In a typical general jurisdiction case under international shoe, a company is subject to suit on any claim in a forum state only because of its decision to file a piece of paper there, a certificate of incorporation. The firm is amenable to suit even if all of its operations are located elsewhere, and even if its certificate only sits collecting dust on an office shelf for years thereafter. Then there is the tag rule. The invisible state line might seem a trivial thing, but when an individual takes one step off a plane after flying from New Jersey to California, the jurisdictional consequences are immediate and serious. Consider, too, just a few other examples. A defendant who appears specially to contest jurisdiction preserves his defense, but one who forgets can lose his. Failing to comply with certain pretrial court orders, signing a contract with a forum selection clause, accepting an in-state benefit with jurisdictional strings attached, all these actions as well can carry with them profound consequences for personal jurisdiction. The truth is, under our precedents, a variety of actions of the defendant that may seem like technicalities, nonetheless can amount to a legal submission to the jurisdiction of a court. That was so before international shoe, and it remains so today. Should we overrule them all? Taking Norfolk Southern's argument seriously would require just that. But, tellingly, The company does not follow where its argument leads or even acknowledge its implications. Instead, Norfolk Southern asks us to pluck out and overrule just one long-standing precedent that it happens to dislike. We decline the invitation. There is no fair play or substantial justice in that. Not every case poses a new question. This case poses a very old question indeed, one this court resolved more than a century ago in Pennsylvania Fire. Because that decision remains the law, the judgment of the Supreme Court of Pennsylvania is vacated, and the case is remanded. It is so ordered. Justice Alito, concurring in part and concurring in the judgment. The sole question before us is whether the Due Process Clause of the 14th Amendment is violated when a large out-of-state corporation with substantial operations in OR state complies with a registration requirement that conditions the right to do business in that state on the registrant's submission to personal jurisdiction in any suits that are brought there. I agree with the court that the answer to this question is no. Assuming that the Constitution allows a state to impose such a registration requirement, I see no reason to conclude that such suits violate the corporation's right to fair play and substantial justice. I am not convinced, however, that the Constitution permits a state to impose such a submission to jurisdiction requirement. A state's assertion of jurisdiction over lawsuits with no real connection to the state may violate fundamental principles that are protected by one or more constitutional provisions, or by the very structure of the federal system that the Constitution created. At this point in the development of our constitutional case law, the most appropriate home for these principles is the so-called Dormant Commerce Clause. Norfolk Southern appears to have asserted a Commerce Clause claim below, but the Pennsylvania Supreme Court did not address it. Presumably, Norfolk Southern can renew the challenge on remand. I therefore agree that we should vacate the Pennsylvania Supreme Court's judgment and remand the case for further proceedings. When Virginia resident Robert Mallory initiated this suit, Norfolk Southern Railway Company, a railroad that was at that time incorporated and headquartered in Virginia, had long operated rail lines and conducted related business in Pennsylvania. Consistent with Pennsylvania law, the company had registered as a foreign corporation, most recently in 1998. Then, as now, Pennsylvania law expressly provided that qualification as a foreign corporation was a sufficient basis for Pennsylvania courts to exercise general personal jurisdiction over an out-of-state company. Norfolk Southern is a sophisticated entity, and we may presume that it acted with knowledge of state law when it registered. As a result, we may also presume that by registering, it consented to all valid conditions imposed by state law. I do not understand Norfolk Southern to challenge this basic premise. Instead, Norfolk Southern argues that giving force to the company's consent would violate the 14th Amendment's Due Process Clause. That argument is foreclosed by our precedent. We addressed this question more than a century ago in Pennsylvania Fire Inns. Company of Philadelphia v. Gold Issue Mining and Milling Company there. An Arizona mining company sued a Pennsylvania insurance company in a Missouri court, alleging claims arising from events in Colorado. The Pennsylvania insurance company had obtained a license to do business in Missouri, and so had complied with a Missouri statute requiring the company to execute a power of attorney consenting to service of process on the state insurance superintendent in exchange for licensure. The Missouri Supreme Court had previously construed such powers of attorney as consent to jurisdiction in Missouri for all claims, including those arising from transactions outside the state. Because the insurance company had executed the power of attorney to obtain its license, the court held that Missouri had jurisdiction over the company in that suit. We affirmed in a brief opinion, holding that the construction of Missouri's statute and its application to the Pennsylvania insurance company under the circumstances of the case did not violate due process. The parallels between Pennsylvania Fire and the case before us are undeniable. In both, a large company incorporated in one state was actively engaged in business in another state. In connection with that business, both companies took steps that, under the express terms or previous authoritative construction of state law, were understood as consent to the state's jurisdiction in suits on all claims, no matter where the events underlying the suit took place. In both cases, an out-of-state plaintiff sued the out-of-state company, alleging claims unrelated to the company's forum state conduct. And in both, the out-of-state company objected, arguing that holding it to the terms of its consent would violate the 14th Amendment's Due Process Clause. In Pennsylvania Fire, we held that there was no due process violation in these circumstances. Given the near-complete overlap of material facts, that holding, unless it has been overruled, is binding here. Norfolk Southern has not persuaded me that Pennsylvania Fire has been overruled. While we have infrequently invoked that decision's due process holding, we have never expressly overruled it, nor can I conclude that it has been impliedly overruled. Norfolk Southern cites the international shoe line of cases, but those cases involve constitutional limits on jurisdiction over non-consenting corporations. Consent is a separate basis for personal jurisdiction. Pennsylvania Fire's holding, insofar as it is predicated on the out-of-state company's consent, is not inconsistent with international shoe or its progeny. Nor would I overrule Pennsylvania Fire in this case, as Norfolk Southern requests. At the least, Pennsylvania Fire's holding does not strike me as egregiously wrong in its application here. Requiring Norfolk Southern to defend against Mallory's suit in Pennsylvania, as opposed to in Virginia, is not so deeply unfair that it violates the railroad's constitutional right to due process. The company has extensive operations in Pennsylvania, has availed itself of the Pennsylvania courts on countless occasions, and had clear notice that Pennsylvania considered its registration as consent to general jurisdiction. Norfolk Southern's conduct and connection with Pennsylvania are such that it should reasonably anticipate being hailed into court there. If having to defend this suit in Pennsylvania seems unfair to Norfolk Southern, it is only because it is hard to see Mallory's decision to sue in Philadelphia as anything other than the selection of a venue that is reputed to be especially favorable to tort plaintiffs. But we have never held that the Due Process Clause protects against forum shopping. Perhaps for that understandable reason, no party has suggested that we go so far. For these reasons, I agree that Pennsylvania Fire controls our decision here, but I stress that it does so due to the clear overlap with the facts of this case. While that is the end of the case before us, it is not the end of the story for registration-based jurisdiction. We have long recognized that the Constitution restricts a state's power to reach out and regulate conduct that has little if any connection with the state's legitimate interests. This principle, an obvious and necessary result of our constitutional order, is not confined to any one clause or section, but is expressed in the very nature of the federal system that the Constitution created, and in numerous provisions that bear on states' interactions with one another. The dissent suggests that we apply this principle through the Due Process Clause of the 14th Amendment, and there is support for this argument in our case law, if not in the ordinary meaning of the provision's wording. By its terms, the Due Process Clause is about procedure, but over the years, it has become a refuge of sorts for constitutional principles that are not procedural, but would otherwise be homeless as the result of having been exiled from the provisions in which they may have originally been intended to reside. This may be true, for example, with respect to the protection of substantive rights that might otherwise be guaranteed by the 14th Amendment's Privileges and Immunities Clause. And in a somewhat similar way, our due process decisions regarding personal jurisdiction have often invoked respect for federalism as a factor in their analyses. In our first decision holding that the 14th Amendment's Due Process Clause protects a civil defendant from suit in certain fora, the court proclaimed that no state can exercise direct jurisdiction and authority over persons or property without its territory. The several states, the court explained, are of equal dignity and authority, and the independence of one implies the exclusion of power from all others. The court warned that, in certain circumstances, a state's exercise of jurisdiction over non-residents would be an encroachment upon the independence of another state, and a usurpation of that state's authority. And the court noted that this was not a newly developed doctrine, but reflected well-established principles of public law that had been frequently expressed, in opinions of eminent judges, and carried into adjudications in numerous cases. Our post-international shoe decisions have continued to recognize that constitutional restrictions on state court jurisdiction are more than a guarantee of immunity from inconvenient or distant litigation, but reflect territorial limitations on state power. And we have recognized that in some circumstances, federalism interests may be decisive in the due process analysis. Despite these many references to federalism in due process decisions, there is a significant obstacle to addressing those concerns through the 14th Amendment here. We have never held that a state's assertion of jurisdiction unconstitutionally intruded on the prerogatives of another state when the defendant had consented to jurisdiction in the forum state. Indeed, it is hard to see how such a decision could be justified. The Due Process Clause confers a right on persons, not states. If a person voluntarily waives that right, that choice should be honored. The federalism concerns that this case presents fall more naturally within the scope of the Commerce Clause. By its terms, the Commerce Clause grants Congress the power to regulate commerce among the several states. But this court has long held that the clause includes a negative component, the so-called Dormant Commerce Clause, that prohibits state laws that unduly restrict interstate commerce. While the notion that the Commerce Clause restrains states has been the subject of thoughtful critiques, the concept is deeply rooted in our case law and vindicates a fundamental aim of the Constitution: fostering the creation of a national economy and avoiding the every state for itself practices that had weakened the country under the Articles of Confederation. The framers might have thought other provisions would fill that role, but at this point in the court's history, no provision other than the Commerce Clause could easily do the job. In its negative aspects, the Commerce Clause serves to mediate the states' competing claims of sovereign authority to enact regulations that affect commerce among the states. It is especially appropriate to look to the Dormant Commerce Clause in considering the constitutionality of the authority asserted by Pennsylvania's registration scheme. Because the right of an out-of-state corporation to do business in another state is based on the Dormant Commerce Clause, it stands to reason that this doctrine may also limit a state's authority to condition that right. This court and other courts have long examined assertions of jurisdiction over out-of-state companies in light of interstate commerce concerns. Consider Davis v. Farmers Cooperative Equity Company, a case very much like the one now before us. In Davis, a Kansas company sued a Kansas railroad in Minnesota on a claim that was in no way connected with Minnesota. Jurisdiction over the railroad was based on its compliance with a state statute regulating the in-state activities of out-of-state corporations. The railroad maintained a soliciting agent in Minnesota, and the Minnesota Supreme Court had interpreted state law as compelling out-of-state carriers, as a condition of maintaining a soliciting agent, to submit to suit in Minnesota on any cause of action, wherever it may have arisen. The Minnesota Supreme Court upheld jurisdiction against the railroad, but we reversed, holding that Minnesota's condition imposed upon interstate commerce a serious and unreasonable burden, which renders the statute obnoxious to the Commerce Clause. By requiring from interstate carriers general submission to suit, Minnesota's statute unreasonably obstructed and unduly burdened interstate commerce. Although we have since refined our Commerce Clause framework, the structural constitutional principles underlying these decisions are unchanged, and the clause remains a vital constraint on states' power over out-of-state corporations. In my view, there is a good prospect that Pennsylvania's assertion of jurisdiction here, over an out-of-state company in a suit brought by an out-of-state plaintiff on claims wholly unrelated to Pennsylvania, violates the Commerce Clause. Under our modern framework, a state law may offend the Commerce Clause's negative restrictions in two circumstances: when the law discriminates against interstate commerce, or when it imposes undue burdens on interstate commerce. Discriminatory state laws are subject to a virtually per se rule of invalidity. Once a state law is shown to discriminate against interstate commerce either on its face or in practical effect, the law's proponent must demonstrate both that the statute serves a legitimate local purpose, and that this purpose could not be served as well by available non-discriminatory means. Justification of a discriminatory law faces a high bar to overcome the presumption of invalidity. Laws that even-handedly regulate to advance a legitimate local public interest are subject to a looser standard. These laws will be upheld unless the burden imposed on interstate commerce is clearly excessive in relation to the putative local benefits. In these circumstances, the question becomes one of degree, and the extent of the burden that will be tolerated will depend on the nature of the local interest involved. There is reason to believe that Pennsylvania's registration-based jurisdiction law discriminates against out-of-state companies. But at the very least, the law imposes a significant burden on interstate commerce by requiring a foreign corporation to defend itself with reference to all transactions, including those with no forum connection. The foreseeable consequences of the law make clear why this is so. Aside from the operational burdens it places on out-of-state companies, Pennsylvania's scheme injects intolerable unpredictability into doing business across state borders. Large companies may be able to manage the patchwork of liability regimes, damages caps, and local rules in each state, but the impact on small companies, which constitute the majority of all U.S. corporations, could be devastating. Large companies may resort to creative corporate structuring to limit their amenability to suit. Small companies may prudently choose not to enter an out-of-state market due to the increased risk of remote litigation. Some companies may forego registration altogether, preferring to risk the consequences rather than expand their exposure to general jurisdiction. No one benefits from this efficient breach of corporate registration laws. Corporations must manage their added risk, and plaintiffs face challenges in serving unregistered corporations. States, meanwhile, would externalize the costs of their plaintiff-friendly regimes. Given these serious burdens, to survive Commerce Clause scrutiny under this court's framework, the law must advance a legitimate local public interest, and the burdens must not be clearly excessive in relation to the putative local benefits. But I am hard-pressed to identify any legitimate local interest that is advanced by requiring an out-of-state company to defend a suit brought by an out-of-state plaintiff on claims wholly unconnected to the forum state. A state certainly has a legitimate interest in regulating activities conducted within its borders, which may include providing a forum to redress harms that occurred within the state. A state also may have an interest in providing its residents with a convenient forum for redressing injuries inflicted by out-of-state actors. But a state generally does not have a legitimate local interest in vindicating the rights of non-residents harmed by out-of-state actors through conduct outside the state. With no legitimate local interest served, there is nothing to be weighed to sustain the law. And even if some legitimate local interest could be identified, I am skeptical that any local benefits of the state's assertion of jurisdiction in these circumstances could overcome the serious burdens on interstate commerce that it imposes. Because Pennsylvania Fire resolves this case in favor of petitioner Mallory, and no Commerce Clause challenges before us, I join the court's opinion as stated in Parts 1 and 3b, and agree that the Pennsylvania Supreme Court's judgment should be vacated and the case remanded for further proceedings. Justice Jackson, concurring. I agree with the court that this case is straightforward under our precedents. I write separately to say that, for me, What makes it so is not just our ruling in Pennsylvania Fire Insurance Company of Philadelphia v. Gold, Issue Mining and Milling Company. I also consider our ruling in Insurance Corporation of Ireland v. Compagnie de Bauxites de Guinea to be particularly instructive. In Insurance Corporation of Ireland, this court confirmed a simple truth. The due process requirement of personal jurisdiction is an individual, waivable right. The requirement exists to ensure that the forum state has sufficient contacts with the defendant, such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. We noted further that the interstate federalism concerns informing that right are ultimately a function of the individual liberty interest that this due process right preserves. Because the personal jurisdiction right belongs to the defendant, however, we explain that a defendant can choose to subject itself to powers from which it may otherwise be protected. When that happens, a state can exercise jurisdiction over the defendant consistent with the Due Process Clause, even if our personal jurisdiction cases would normally preclude the state from subjecting a defendant to its authority under the circumstances presented. Waiver is thus a critical feature of the personal jurisdiction analysis, and there is more than one way to waive personal jurisdiction rights, as Insurance Corporation of Ireland also clarified. A defendant can waive its rights by explicitly or implicitly consenting to litigate future disputes in a particular state's courts. A defendant might also fail to follow specific procedural rules and end up waiving the right to object to personal jurisdiction as a consequence. Or a defendant can voluntarily invoke certain benefits from a state that are conditioned on submitting to the state's jurisdiction. Regardless of whether a defendant relinquishes its personal jurisdiction rights expressly or constructively, the basic teaching of Insurance Corporation of Ireland is the same. When a defendant chooses to engage in behavior that amounts to a legal submission to the jurisdiction of the court, the Due Process Clause poses no barrier to the court's exercise of personal jurisdiction. In my view, there is no question that Norfolk Southern waived its personal jurisdiction rights here. As the court ably explains, Norfolk Southern agreed to register as a foreign corporation in Pennsylvania, in exchange for the ability to conduct business within the Commonwealth and receive associated benefits. Moreover, when Norfolk Southern made that decision, the jurisdictional consequences of registration were clear. Foreign corporations are given reasonable notice of the jurisdictional implications of registration. Nor was Norfolk Southern compelled to register and submit itself to the general jurisdiction of Pennsylvania courts simply because its trains pass through the Commonwealth. Registration is required when corporations seek to conduct local business in a regular, systematic, or extensive way. Norfolk Southern apparently deemed registration worthwhile and opted in. Under Insurance Corporation of Ireland, the due process question that this case presents is easily answered. Having made the choice to register and do business in Pennsylvania despite the jurisdictional consequences, and having thereby voluntarily relinquished the due process rights our general jurisdiction precedents afford, Norfolk Southern cannot be heard to complain that its due process rights are violated by having to defend itself in Pennsylvania's courts. Whether Pennsylvania could have asserted general jurisdiction over Norfolk Southern absent any waiver is beside the point. In other areas of the law, we permit states to ask defendants to waive individual rights and safeguards. For example, allowing plea bargains to waive a defendant's trial rights and the right against self-incrimination or waiver of speedy trial rights. Moreover, when defendants do so, we respect that waiver decision and hold them to that choice, even though the government could not have otherwise bypassed the rules and procedures those rights protect. Insisting that our general jurisdiction precedents preclude Pennsylvania from subjecting corporations to suit within its borders, despite their waiver of the protections those precedents entail, puts the personal jurisdiction requirement on a pedestal. But there is nothing unique about the requirement of personal jurisdiction that prevents it from being waived like other individual rights. In short, Insurance Corporation of Ireland makes clear that the personal jurisdiction requirement is an individual, waivable right, and I agree with the court that Norfolk Southern waived that right by choosing to register as a foreign corporation under the circumstances presented in this case. Therefore, I perceive no due process problem with the registration statute at issue here. Justice Barrett, with whom the Chief Justice, Justice Kagan, and Justice Kavanaugh join, dissenting. For 75 years, we have held that the Due Process Clause does not allow state courts to assert general jurisdiction over foreign defendants merely because they do business in the state. Pennsylvania nevertheless claims general jurisdiction over all corporations that lawfully do business within its borders. As the Commonwealth's own courts recognized, that flies in the face of our precedent. The court finds a way around this settled rule. All a state must do is compel a corporation to register to conduct business there, as every state does, and enact a law making registration sufficient for suit on any cause, as every state could do. Then, every company doing business in the state is subject to general jurisdiction based on implied consent, not contacts. That includes suits, like this one, with no connection whatsoever to the forum. Such an approach does not formally overrule our traditional context-based approach to jurisdiction, but it might as well. By relabeling their long-arm statutes, states may now manufacture consent to personal jurisdiction. Because I would not permit state governments to circumvent constitutional limits so easily, I respectfully dissent. Personal jurisdiction is the authority of a court to issue a judgment that binds a defendant. If a defendant submits to a court's authority, the court automatically acquires personal jurisdiction. But if a defendant contests the court's authority, the court must determine whether it can nevertheless assert coercive power over the defendant. That calculus turns first on the statute or rule defining the persons within the court's reach. It depends next on the Due Process Clause, which guards a defendant's right to resist the judicial authority of a sovereign to which it has an insufficient tie. The clause has the companion role of ensuring that state courts do not reach out beyond the limits imposed on them by their status as co-equal sovereigns in a federal system. Our precedent divides personal jurisdiction into two categories, specific and general. Both are subject to the demands of the Due Process Clause. Specific jurisdiction, as its name suggests, allows a state court to adjudicate specific claims against a defendant. When a defendant purposefully avails itself of the privilege of conducting activities within the forum state, that state's courts may adjudicate claims that arise out of or relate to the defendant's contacts with the forum. General jurisdiction, by contrast, allows a state court to adjudicate any and all claims brought against a defendant. This sweeping authority exists only when the defendant's connection to the state is tight. So tight, in fact, that the defendant is at home there. An individual is typically at home in her domicile, and a corporation is typically at home in both its place of incorporation and principal place of business. Absent an exceptional circumstance, general jurisdiction is cabined to these locations. This case involves a Pennsylvania statute authorizing courts to exercise general jurisdiction over corporations that are not at home in the Commonwealth. All foreign corporations must register to do business in Pennsylvania, and all registrants are subject to suit on any cause in the Commonwealth's courts. The statute thus purports to empower Pennsylvania courts to adjudicate any and all claims against corporations doing business there. As the Pennsylvania Supreme Court recognized, this statute clearly, palpably, and plainly violates the Constitution. Look no further than a case with remarkably similar facts, and one that the court conspicuously ignores. There, we assessed whether Montana's courts could exercise general jurisdiction over the BNSF Railroad. No plaintiff resided in Montana or suffered an injury there. Like Mallory, one of the plaintiffs alleged that the railroad exposed him to toxic substances that caused his cancer. Like Norfolk Southern, BNSF had tracks and employees in the forum, but it was neither incorporated nor headquartered there. We rejected Montana's assertion of general jurisdiction over BNSF because in-state business does not suffice to permit the assertion of general jurisdiction over claims that are unrelated to any activity occurring in the state. Daimler and Goodyear, we explained, could not have made that any clearer. The same rule applies here. The Pennsylvania statute announces that registering to do business in the Commonwealth shall constitute a sufficient basis for general jurisdiction. But as our precedent makes crystal clear, simply doing business is insufficient. Absent an exceptional circumstance, a corporation is subject to general jurisdiction only in a state where it is incorporated or has its principal place of business. Adding the antecedent step of registration does not change that conclusion. If it did, every corporation would be subject to general jurisdiction in every state in which it registered, and Daimler's ruling would be robbed of meaning by a backdoor thief. The court short-circuits this precedent by characterizing this case as one about consent rather than context-based jurisdiction. Consent is an established basis for personal jurisdiction, which is, after all, a waivable defense. A variety of legal arrangements have been taken to represent express or implied consent to the personal jurisdiction of the court, including contract, stipulation, and in-court appearance. Today, the court adds corporate registration to the list. This argument begins on shaky ground because Pennsylvania itself does not treat registration as synonymous with consent. Section 5301A(2)(I) baldly asserts that qualification as a foreign corporation in the Commonwealth is a sufficient hook for general jurisdiction. The next subsection permits the exercise of general jurisdiction over a corporation based on consent to the extent authorized by the consent. If registration were actual consent, one would expect to see some mention of jurisdiction in Norfolk Southern's registration paperwork, which is instead wholly silent on the matter. What Mallory calls consent is what the Pennsylvania Supreme Court called compelled submission to general jurisdiction by legislative command. Corporate registration triggers a statutory repercussion, but that is not consent in a conventional sense of the word. To pull Section 5301A(2)(I) under the umbrella of consent, the court, following Mallory, casts it as setting the terms of a bargain. In exchange for access to the Pennsylvania market, a corporation must allow the Commonwealth's courts to adjudicate any and all claims against it, even those, like Mallory's, having nothing to do with Pennsylvania. Everyone is charged with knowledge of the law, so corporations are on notice of the deal. By registering, they agree to its terms. While this is a clever theory, it falls apart on inspection. The court grounds consent in a corporation's choice to register with knowledge, constructive or actual, of the jurisdictional consequences. But on that logic, any long-arm statute could be said to elicit consent. Imagine a law that simply provides, any corporation doing business in this state is subject to general jurisdiction in our courts. Such a law defies our precedent, which holds that in-state business does not suffice to permit the assertion of general jurisdiction. Yet this hypothetical law, like the Pennsylvania statute, gives notice that general jurisdiction is the price of doing business, and its notice is no less clear than Pennsylvania's. So on the court's reasoning, corporations that choose to do business in the state impliedly consent to general jurisdiction. The result, a state could defeat the Due Process Clause by adopting a law at odds with the Due Process Clause. That makes no sense. If the hypothetical statute overreaches, then Pennsylvania's does too. As the United States observes, invoking the label consent rather than general jurisdiction does not render Pennsylvania's long-arm statute constitutional. Yet the court takes this route without so much as acknowledging its circularity. While our due process precedent permits states to place reasonable conditions on foreign corporations in exchange for access to their markets, there is nothing reasonable about a state extracting consent in cases where it has no connection whatsoever. The Due Process Clause protects more than the rights of defendants, it also protects interstate federalism. We have emphasized this principle in case after case. For instance, we stress that restrictions on personal jurisdiction are more than a guarantee of immunity from inconvenient or distant litigation. They are a consequence of territorial limitations on the power of the respective states. We explain that even if the defendant would suffer minimal or no inconvenience from being forced to litigate before the tribunals of another state, the Due Process Clause, acting as an instrument of interstate federalism, may sometimes act to divest the state of its power to render a valid judgment. And we reinforce that this federalism interest may be decisive. A defendant's ability to waive its objection to personal jurisdiction reflects that the clause protects, first and foremost, an individual right. But when a state announces a blanket rule that ignores the territorial boundaries on its power, federalism interests are implicated too. Pennsylvania's effort to assert general jurisdiction over every company doing business within its borders infringes on the sovereignty of its sister states in a way no less exorbitant and grasping than attempts we have previously rejected. Conditions on doing in-state business cannot be inconsistent with those rules of public law which secure the jurisdiction and authority of each state from encroachment by all others. Permitting Pennsylvania to impose a blanket claim of authority over controversies, with no connection to the Commonwealth, intrudes on the prerogatives of other states, domestic and foreign, to adjudicate the rights of their citizens and enforce their own laws. The plurality's response is to fall back, yet again, on consent. In its view, because a defendant can waive its personal jurisdiction right, a state can never overreach in demanding its relinquishment. That is not how we treat rights with structural components. The right to remove a case to federal court, for instance, is primarily personal. It secures for a non-resident defendant a federal forum thought to be more impartial. At the same time, however, it serves federal interests by ensuring that federal courts can vindicate federal rights. Recognizing this dual role, we have rejected efforts of states to require defendants to relinquish this waivable right to removal as a condition of doing business. The same logic applies here. Pennsylvania's power grab infringes on more than just the rights of defendants, it upsets the proper role of the states in our federal system. The plurality attempts to minimize the novelty of its conclusion by pointing to our decision in Burnham v. Superior Court of California. There, we considered whether tag jurisdiction personal service upon a defendant physically present in the forum state remains an effective basis for general jurisdiction after international shoe. We unanimously agreed that it does. The plurality claims that registration jurisdiction for a corporation is just as valid as the tag jurisdiction that we approved in Burnham. But in drawing this analogy, the plurality omits any discussion of Burnham's reasoning. In Burnham, we acknowledge that tag jurisdiction would not satisfy the context-based test for general jurisdiction. Nonetheless, we reasoned that tag jurisdiction is both firmly approved by tradition and still favored, making it one of the continuing traditions of our legal system that defines the due process standard of traditional notions of fair play and substantial justice. Burnham thus permits a long-standing and still accepted basis for jurisdiction to pass international shoes test. General jurisdiction by registration flunks both of these prongs. It is neither firmly approved by tradition nor still favored. Thus, the plurality's analogy to tag jurisdiction is superficial at best. Start with the second prong. In Burnham, we did not know of a single state that had abandoned in-state service as a basis of jurisdiction. Here, as Mallory concedes, Pennsylvania is the only state with a statute treating registration as sufficient for general jurisdiction. Indeed, quite a few have jettisoned the jurisdictional consequences of corporate registration altogether, and in no uncertain terms. With the Pennsylvania legislature standing alone, the plurality does not even attempt to describe this method of securing general jurisdiction as still favored or reflective of our common understanding now. Quite the opposite. The plurality denigrates the spirit of our age reflected by the vast majority of states, and appeals to its own notions of fairness. The past is as fatal to the plurality's theory as the present. Burnham's tradition prong asks whether a method for securing jurisdiction was shared by American courts at the crucial time, 1868, when the 14th Amendment was adopted. But the plurality cannot identify a single case from that period supporting its theory. In fact, the evidence runs in the opposite direction. Statutes that required the appointment of a registered agent for service of process were far more modest than Pennsylvania's, and even when a statute was written more broadly, state courts generally understood it to implicitly limit jurisdiction to suits with a connection to the forum. The state reporters are replete with examples of judicial decisions that stood by the then prevailing rule. Compliance with a registration law did not subject a foreign corporation to suit on any cause in a state, but only those related to the forum. Our cases from this era articulate the same line. Although plaintiffs typically did not sue defendants in fora that had no rational relation to causes of action, courts repeatedly turned them away when they did. Sidestepping Burnham's logic, the plurality seizes on its bottom line approval of tag jurisdiction. According to the plurality, tag jurisdiction, based on physical presence, and registration jurisdiction, based on deemed consent, are essentially the same thing, so by blessing one, Burnham blessed the other. The plurality never explains why they are the same, even though, as we have just discussed, more than a century's worth of law treats them as distinct. The plurality's rationale seems to be that if a person is subject to general jurisdiction anywhere she is present, then a corporation should be subject to general jurisdiction anywhere it does business. That is not only a non sequitur, it is contrary to the historical rationale of international shoe. Before international shoe, a state court's power over a person turned strictly on service of process within the state, presence, or her voluntary appearance, consent. In response to changes in interstate business and transportation in the late 19th and early 20th centuries, states deployed new legal fictions designed to secure the presence or consent of non-resident individuals and foreign corporations. For example, state laws required non-resident drivers to give their implied consent to be sued for their in-state accidents as a condition of using the road, and foreign corporations, as we have discussed, were required by statute to consent to the appointment of a resident agent, so that the company could then be constructively present for in-state service. Such extensions of consent and presence were purely fictional, and can no longer stand after international shoe. The very point of international shoe was to cast aside the legal fictions built on the old territorial approach to personal jurisdiction, and replace them with its contacts-based test. In Burnham, we upheld tag jurisdiction because it is not one of those fictions, it is presence. By contrast, Pennsylvania's registration statute is based on deemed consent, and this kind of legally implied consent is one of the very fictions that our decision in international shoe swept away. Neither Justice Alito nor the plurality seriously contest this history, nor does either deny that Mallory's theory would gut Daimler. Instead, they insist that we already decided this question in a pre-international shoe precedent, Pennsylvania Fire Inns, Company of Philadelphia v. Gold Issue Mining and Milling Company. In Pennsylvania, Fire, an Arizona corporation sued a Pennsylvania corporation in Missouri for a claim arising from an insurance contract issued in Colorado and protecting property in Colorado. The defendant maintained that the Missouri court lacked personal jurisdiction over it because the plaintiff's claim had no connection to the forum. But in compliance with Missouri law, the defendant company had previously filed a power of attorney consenting that service of process upon the superintendent of the state's insurance department should be deemed personal service upon the company. The Missouri Supreme Court construed that power of attorney as express consent to personal jurisdiction in Missouri in any case whatsoever, and this court held that the construction did not deprive the defendant of due process of law. The court asserts that Pennsylvania Fire controls our decision today. I disagree. The case was decided before this court's transformative decision on personal jurisdiction in international shoe, and we have already stated that prior decisions that are inconsistent with this standard are overruled. Pennsylvania Fire fits that bill. Time and again, we have reinforced that doing business tests like those framed before specific jurisdiction evolved in the United States are not a valid basis for general jurisdiction. The only innovation of Pennsylvania's statute is to make doing business synonymous with consent. If Pennsylvania Fire endorses that trick, then Pennsylvania Fire is no longer good law. The plurality tries to get around international shoe by claiming that it did no more than expand jurisdiction, affecting nothing that came before it. That is as fictional as the old concept of corporate presence on which the plurality relies. We have previously abandoned even ancient bases of jurisdiction for incompatibility with international shoe, and we have repeatedly reminded litigants not to put much stock in our pre-international shoe decisions. Daimler itself reinforces that pre-international shoe decisions should not attract heavy reliance today. Over and over, we have reminded litigants that international shoe is canonical, seminal, pathmarking, and even momentous, to give just a few examples. Yet the court acts as if none of this ever happened. In any event, I doubt Pennsylvania Fire would control this case even if it remained valid. Pennsylvania Fire distinguished between express consent, that is, consent actually conferred by the document, and deemed consent, inferred from doing business. As Judge Learned Hand emphasized in a decision invoked by the plurality, without express consent, the normal rules apply. The express power of attorney in Pennsylvania Fire made service on the insurance superintendent the equivalent of a corporate vote that had accepted service in this specific case. Norfolk Southern, by contrast, executed no document like the power of attorney there. The court makes much of what Norfolk Southern did right on its forms. It named a commercial registered office provider. It notified Pennsylvania of a merger, and it paid $70 to update its paperwork. None of those documents use the word agent. Nothing hints at the word jurisdiction. And, as the Pennsylvania Supreme Court explained, nothing about that registration is voluntary. Consent in Pennsylvania Fire was contained in the document itself. Here it is deemed by statute. If mere formalities matter as much as the plurality says they do, it should respect this one too. By now, it should be clear that the plurality's primary approach to this case is to look past our personal jurisdiction precedent, relying on a fact sheet downloaded from the internet. For instance, the plurality argues that Norfolk Southern is such a part of the Pennsylvania community, and does so much business there, that its presence in Pennsylvania is enough to require it to stand for suits having nothing to do with the Commonwealth. In Daimler, however, we roundly rejected the plaintiff's request that we approve the exercise of general jurisdiction in every state in which a corporation engages in a substantial, continuous, and systematic course of business. The established test, which the plurality barely acknowledges, is whether the corporation is at home in the state. A corporation that operates in many places, and must therefore register in just as many, can scarcely be deemed at home in all of them. Critics of Daimler and Goodyear may be happy to see them go. And make no mistake, they are halfway out the door. If states take up the court's invitation to manipulate registration, Daimler and Goodyear will be obsolete, and, at least for corporations, specific jurisdiction will be superfluous. Because I would not work this sea change, I respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.